All right, hello everyone. My name is Ashley Plies. I'm part of the Arctic Innovation staff, Arctic Innovation Competition staff here. And this is our US Patent and Trademark Partnership Office partnership, sorry. And we're super excited, and hopefully this helps all our competitors get their ideas off the ground. And I will hand it over to Julie Mason and Jeffrey Palaniuk.
Hello, everybody. Thank you for having the USPTO share some information with you this evening. We're excited because we heard many of you are participating in the Arctic Innovation Competition, or you may have some ideas or something creative that you'd like to take to the next step. And so hopefully the information that we provide you this evening will help you on that journey. We're going to do a few things tonight, and let me share my screen here and get started with how you can protect your creativity. That's what we really wanted to look at. So before we get started, I've got a disclaimer I want to show you. Throughout the presentation, I'm going to show you products like this, the Coca-Cola, and this. And when you see those products, this disclaimer basically states that the U.S. Patent and Trademark Office does not endorse any of these products. They are just used for educational purposes. So just keep that in mind as we go through this presentation. So a little bit about where Jeff and I are from. The U.S. Patent and Trademark Office is known as America's Innovation Agency. We are located back in the Washington, D.C. area, in fact, in Alexandria, Virginia. And we are basically in charge of the intellectual property system, which you're going to learn more about in this presentation. And I actually happen to be located in one of our regional offices down in San Jose, California. Jeff is actually a patent examiner, and he is part of a telework program we have, and he's located in Colorado. And you will find that we are all over the United States, but for the West Coast and for Alaska, we're kind of your office in Silicon Valley. And this is a little bit about our office. We have about 70 patent examiners there, and we have patent trial and appeal board judges as well. So you'll learn a little bit more about that as we go through the presentation tonight. So let's get started. What do you think intellectual property means? Well, when you think of property, you think of something you own, some tangible item you might own, like your parents may own a house, you may own a bicycle or skis or a car. But intellectual property is something that you create. It's an idea you have, and that's what we're going to talk about this evening, how you can protect those ideas, and those ideas that you actually put in a tangible form. Years ago, when the Constitution was being drawn up, our forefathers had the foresight that authors, inventors, they needed to be protected with their invention. And so it is actually part of the Constitution. And if you look at U.S. Constitution, Article 1, Section 8, Clause 8, it says the Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right, and that's a very important word, the exclusive right to their respective writings and discoveries. And so first of all, you have to think, well, what type of property am I protecting? And and how am I protecting it? And if you've got a business or an idea that you're starting, how do you know what type of intellectual property to use? Well, we've got four types of intellectual property, and you're looking at this screen saying, well, wait a minute, Julie, I see six boxes here, but let me clarify that. The top row illustrates patents. That's one type of intellectual property. And within patents, you can have three types of patents. There's the utility patent, which a lot of you might be familiar with. If you've ever watched Shark Tank, or you've bought a product in the store, or watched an infomercial on TV for a new product and it says patent pending, um, that protects inventions that you might have. And a design patent is more ornamental, and you can see there's a picture of R2D2. Um, George Lucas, when he created the original Star Wars movies, he actually applied for design patents for many of the characters. And I mean, R2D2 is a robot in the movie, but he really doesn't have functionality. George Lucas was actually patenting the look of that robot or that character in the Star Wars movie. And then the third type of patent is a plant patent. So if any of you have ever eaten a cutie, one of those little mandarins, and they're really yummy, usually juicy and sweet. They're usually in the stores around the holidays. Um, they actually came from a plant patent. Now, you can't just go into nature and discover a new plant and patent it. It has to be something that had some sort of human interference where it was asexually reproduced, or a hybrid plant that had some sort of human interaction with it. You can't just discover a plant occurring in nature and patent that plant. So that's the first type of intellectual property, patents. The second type of intellectual property is trade secrets. And again, this example of Coca-Cola is a really good example of a trade secret. Now, there are a lot of colas when you go into the store. Some of you may have like Pepsi Cola, maybe have RC Cola, Shasta Cola, the store brand cola. They all taste fairly similar. They're all colas, but they're not exactly the same taste as Coca-Cola. There's a slight difference, and they've kept their formula for this secret. Now you can reverse engineer it and find it out, but there's something in the process that they do that you can't detect by reverse engineering the product. So they've kept that a trade secret, so they haven't patented it at all. And so nobody really knows what their secret process is for making Coca-Cola. Trademarks is a third type of intellectual property, and trademarks you all see everywhere. And in fact, I've got an example here. Skittles, Taste the Rainbow. Again, with Coca-Cola, the trademark Coca-Cola, the red and the white. Um, in this picture, you see an example of NBC, and another trademark is that NBC chimes, NBC, that also can be trademarked. So that's a third type of intellectual property, kind of protecting your brand or the name of your product, or the look of your product. And then the final type of intellectual property, which I know all of you have already done, is copyright. And anytime that you produce a story or a new song that you've written or made up, um, a new piece of artwork that you've created, that's copyright. And you actually get copyright the minute you create something like that. But there is also a copyright office where you can get that creation registered. So whenever you pick up a book or you see a movie, you see that C with a circle around it. That's your copyright right there. So again, 4 types of copyright, intellectual property: patents, trade secrets, trademarks, and copyright. So let me ask you a question. Can you find the types of intellectual property protection in a mobile phone? So take a look at that picture, and if you all have access to the chat box, type in what types of intellectual property you might see on a mobile phone. And there's 2 examples on the screen. Any ideas? Okay, well, you see the Apple logo, you saw the Samsung name, you see the way the phone looks, and in fact, the iPhone has rounded the corners on it. That was a design patent. The way the phone works, the touch screen, those can all be utility patents. There's probably a lot of algorithms and different components that they haven't really shared how they work, and those can be trade secrets. The ringtones, you all might have a specific ringtone that's associated with your device. That's a popular song or a phrase, and that also is copyrighted. So just intellectual property is all around you. So again, what are the 4 types of intellectual property? If you want to type them in, I'd love to hear from you. I'll give you a minute. But in the essence of time, maybe we ought to go on. So let's start with trademarks, and we'll just go into a little bit more detail with trademarks. So when you see this symbol, as soon as you see it, do you know what brand it is? Anybody? Well, it's Nike, right? You see that swoosh mark? That's their trademark. You know, if you're buying any type of sporting goods with that swoosh mark on it, that is a Nike product. And then they also have trademarked their tagline, "Just do it." And those are different things that you can trademark to really help build a brand for your product. So a trademark can be any word, symbol, device that is used to identify goods and services, and to indicate their source. And that's really important. You know who made the product and where it's coming from and what that product is. Um, so let's say you walked into a store and this is what the toothpaste looked like when you went to pick it up, or you wanted to buy a drink and this is what you had to choose from. Without that trademark, you don't know what's inside, where that product came from. Did Coca-Cola make it? Did Pepsi make it? It's very important to have that identification of the goods and the source that they came from. So you as a consumer can make a choice. Hey, I like Pepsi better than Coke. I'm going to buy a Pepsi. You can have different types of trademarks. So once you get your mark or your product, you might first want to trademark the name of the product, but then as you're designing how the label's going to look like and the colors that you want to have to help identify your product, you can create a logo and you're a composite mark. So there are all different types of trademarks that you can have. And then this is just an example of the different types of trademarks. Even the shape of the Coca-Cola bottle is trademarked. And if you all picked up your STEM kits, there was a piece of candy inside your STEM kit. When you touch this candy, even if it were dark and you reached into that bag and felt that candy, you would know probably what candy it is just by the shape of it. And you would look at it and how it's wrapped. This is completely trademarked and illustrates a series of trademarks and trade dress registrations with our office to protect Hershey Kisses. So no other candy can have this shape or this brand or this look. Let me, yep. So let's ask you, and actually, let me go back to this slide really quickly. A couple of other things to note: you can actually trademark a smell. You can trademark a particular sound. You hear the lion roar in MGM pictures. That is trademark. We talked about the NBC sound, NBC. So keep that in mind. So if you were to look at this one, the UPS truck, can you find the trademarks in this truck and in this picture? There's also a UPS employee there standing next to the truck. Well, there they are. If you look at that truck, the UPS symbol, the color brown that they use, the shape of the truck is trademarked, the little tagline, "What can brown do for you?" Those are all trademarks, and you see them in your everyday life. If you just look around your house and maybe even the clothes you're wearing, you'll notice that you've got trademarks everywhere. All right, trade secret very quickly. We talked about Coca-Cola, Kentucky Fried Chicken, their secret recipe. That's another great example of a trade secret. So again, they're not patented or trademark. The secret recipe is never revealed. And in fact, the employees that work for them sign a non-disclosure agreement, so they can't reveal the secret. So then if you look at these particular pictures, what intellectual property might that represent? Well, this is something you all see every day when you watch a movie or a TV show, when you pick up a book, when you listen to a song on the radio. These are all examples of copyright. And copyright protects, again, original works of authorship, something that you create and put down in a tangible form, like a story or a piece of music or artwork. And this just gives you some examples of the types of creativity that can be copyrighted. And something I want to mention, our office does not grant copyright. That is actually done through the Library of Congress. So you can register if you're writing a book or a short story or a piece of artwork. Maybe it's even artwork you want to have on a t-shirt line that you've created. That piece of artwork would be registered for copyright through the Library of Congress. Now, our office advises on that, but we do not actually register copyright. But again, this gives you an exclusive right to reproduce your work, to display your work, and also to authorize others to do so. So I'm going to turn it over now to Jeff, who is a patent examiner. He is the expert on patents, and let him talk to you about patents.
Okay, thank you, Julie. Let me share my screen real quick here. Let me know when it's coming through.
I don't see it yet, Jeff.
Let's try that again, shall we? Apologies. Okay, are you seeing it now?
Yes, and it's just not in presentation, but there it is. Yes, great.
All right. All right, so I'm going to talk to you about patents really quickly here. So we're going to jet through these. So unlike the other three types of intellectual property that Julie mentioned before, patents are very long. They have a lot of words to them. They have a lot of pictures to them, but they really go into detail about what they're trying to protect. And if there's one word I can impress upon you to remember when it comes to patents, it's the word monopoly. And we all know what you've heard. I imagine most of you have heard of what the game Monopoly is. And it's basically you go for exclusive control. Patents are similar in their idea in that they are granted for, once you get them, you have them for a limited amount of time, but you are the exclusive owner, meaning you are able to exclude other people from making your invention, using it, copying it, doing whatever for a period of time. So as Julie mentioned before, patents come in three flavors. We have plant patents, we have design patents, and we have utility patents. Now, utility patents are what I look at every day. And they, in my opinion, just probably because I work with them, they are the most complex. They also make up probably about 90 to 95% of the types of patents that go through the USPTO. So utility patents cover a lot of ground. So they will cover compositions of matter. So if you've ever taken a chewable vitamin, that is considered to be a composition of matter. Now, they also cover processes, machines. So they'll cover the process for making that vitamin. They'll cover the machine that is used to make those vitamins, and they can also cover the method steps that go into making those vitamins. So as I said, they cover a lot of different aspects of a lot of different inventions. So when I go to look at a particular type of invention, when an application comes across my desk, I look at it for all sorts of different reasons, just to make sure that it satisfies two key elements. One, has it ever been done before? Or two, does it improve upon something that's already been done? And in our particular vernacular, the words we use to define our job, that boils down to, we say novelty. Has it been done before? Is it new? Is it novel? Or is it an improvement? Is it something that isn't obvious to do in light of everything else that has come before it? Now, if you've ever had an idea or seen something that's like, oh my gosh, duh, why didn't I think of that? That's kind of, in a nutshell, that's what we refer to as obvious. Was it obvious to arrive at this particular idea? So as I said, I review applications, and I review applications for these particular ideas amongst several others. But what I do is I take those applications and I read through everything that they set forth, and I basically go to the internet. And for lack of a better way of putting it, I go to the internet. I go to any search databases that we have. I go to magazine articles, social media, Facebook, you name it. If it's out there and if it's available, it's eligible to be used to show that something has been done before. And this is what we call, that we assign a particular term to it. This is what we call prior art. Now, why do we call it art? It's not like a painting. It's not like some of the pieces of art that Julie was showing before. No, art comes from, if you can remember the slide that Julie showed you, codifying inventions and so forth in the Constitution, they refer to it in that passage as art. So we refer to people who create these ideas, we call them skilled artisans because they are skilled in that particular art or technology or field. So in my particular area, I deal with chemistry, I deal with pharmaceuticals, food, drugs, all those particular bits of art I can find and use to reject my, or present an opinion as to why something is or is not patentable. So as we mentioned before, design patents, real quickly, design patents don't have absolutely nothing to do with functionality. So unlike utility patents, design patents and plant patents, I refer to them maybe a little bit tongue-in-cheek as the pretty patents. They're just there to look different. They're design patents, for example. Yes, you can have it for a toothbrush, as you see the banana-shaped toothbrush on the left, or for the particular way a sneaker looks on the right, or as the chairs look in the middle. Do each of those have functionality? Absolutely. Can you get a utility patent for those in addition to a design patent? Absolutely. But the difference between the two is that the design patent just simply covers how something looks. It's ornamentation, as we say. Plant patents, again, I say they are the pretty patents. As Julie mentioned, these are used to protect plants that have been created by hand of man, as we say. Julie mentioned earlier that you can't obtain a patent for something that is naturally grown or something, as we say, is found in nature. Plant patents are granted to new plants that have been created probably in a laboratory, but as she mentioned, hybridization of plants, taking two types of plants and making a new one. Fun fact about plant patents are the only type of patents that are published in color, oftentimes because these patents are granted based on how the plant looks. So why do we want to get a patent? I mean, why do we want to get intellectual property in general? For no better reason to, as I said before, protect that which you're making, protect that which you're trying to create. So we get trademarks, we get copyrights, we maintain things as trade secrets in an effort to protect everything that we are doing. If we're building a business, if we're trying to get funding for a business to grow that business, we want to get something that is going to protect those ideas. We want to be able to use our intellectual property as a tool. It is, after all, property. What do we do with property? We own it. We retain it. We can sell it if we want to. Through the ownership of it, we can say, this is mine, not yours. So you can protect it and guard yourself, guard your business against someone who tries to do harm to it by saying, no, 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 that's my idea. No, actually, I have the patent here. That is my idea. So what we do with our patents is we retain them. We retain them, as we say, for the benefit of the public. So the exchange, I mentioned the word before, monopoly, we retain that exclusive right, but it's an exchange. It is the only legal quid pro quo in the land. Basically, what we do as the patent office is we grant that protection to an inventor in exchange for them fully disclosing what that idea is to the public. So the public is put completely unaware of, completely in the we say it's placed in the public domain, meaning that the public is made completely aware of what the idea is in exchange for granting that inventor the protection to make and use and profit from that invention if possible. So eligibility for a patent. Fun fact, I'd ask, if we had more time, I would ask you the question, what is the minimum age for being able to obtain a patent? But I think we kind of crossed that bridge in our pre-game discussion here. One of the participants, I think tonight, actually already has a patent. So the short answer is there is no age limit. One of the best known examples, everybody's familiar with what a popsicle is. When they were first branded, when they were first created, they were actually called Epsicles after the creator, Frank Epperson, who was an 11-year-old who used soda water to mix with powder and water and he allowed it to just inadvertently, he just let it sit out overnight. And what ended up happening was it froze. And lo and behold, that was the inadvertent discovery of frozen soda water, or Epsicles, later rebranded popsicles, probably because of the carbonated water that was used within them. Pop, soda pop, popsicles. Later on, as you can see, they're rebranding as popsicles with the registered trademark. So short answer to this question: when should you file for a patent application? In this country, as soon as you have the idea together, as soon as you can put together the idea and make it as complete an idea as you can, you want to file for that you want to file for that patent application. I will be honest with you, filing for a patent, it is compared to the other 3 forms of trades of intellectual property. Filing for a patent and obtaining a patent is one of the longer processes that you will probably go through if you elect to go through that way. Trademarks tend to take, I believe, less than a year. Copyrights are really quick and probably the least expensive form of IP that you can submit for. Trade secrets, actually, you don't file any, as Julie mentioned, you don't file anything for those. Those trade secrets are kept internal. So in a complete polar opposite to filing for a patent, obtaining that monopoly and fully disclosing your invention to the public, trade secrets are kept internal. Therefore, if something happens where those get leaked to the public, or you decide to disclose it, or they're inadvertently reverse engineered, there's actually nothing that the patent office can do, because we don't have any part in maintaining or defending, or we have basically nothing to do with trade secrets apart from informing the public of what they are. So patents, as I said, you have your invention, you can file for an application, either a provisional application or a non-provisional application. In exchange, once that patent has been granted, utility patents will grant you protection for up to 20 years. Possibly even longer than that if you go the route of if you file for a provisional application. Patents are also potentially one of the most expensive types of intellectual property that you can file for. As you can see here, this table really quickly, large entities, those are going to be like your major corporations, like your Microsofts, your Abbott Laboratories, your L'Oreal. Small entities are going to be smaller companies, oftentimes a fraction the size of what the large companies are. And then micro entities are your individual inventors, your inventors who make not so much money, who probably need to have some sort of assistance with legal procedures. Pro bono is Latin for free. Oftentimes sometimes micro entities will require free or severely discounted assistance, and that's what we do. We provide a scale of pay, a scalable fee schedule. So as a micro entity, you would qualify for a 75% discount off our fees if you in fact qualify as such an entity. Most first-time inventors, especially ones of your age, probably qualify because there is an income requirement that's less than 200,000. So I'm pretty sure most of everybody here that I'm talking to tonight qualifies. So last real concept that I'm going to take you through here is, what can you do for yourself? Okay, you've gone through the laborious prospect of getting this patent. You've got it. Hooray, you're paying your fees, you're paying exorbitant amount of fees to make sure that you retain this patent. What can you do when someone tries to steal your invention, or as we say, infringe upon your invention? Well, you can advise them of your patent rights. Basically, as I'm sure you've heard the phrase cease and desist. You can advise them that I have the patent, you really need to stop making this is my property. As the second point says, you can send them a cease and desist letter. You can turn around and you can actually offer to license it. And what that means is you'll continue to let them use it, but they have to pay you. Julie mentioned the show Shark Tank. You've heard the term royalties. Well, you can in turn, you can license that invention, you can sell your invention to them, and they can pay you to use your invention. And I'll show you an example of that in a couple slides here. And the other, of course, the other option, the last option, seems to get the most traction, is you can sue for infringement. You can take them to court. You can sue for damages and let the court decide how those inventions will be defended. So I mentioned before, on the road to getting a patent, what my end is to search at basically everything that has come before the application. And why do we search? Basically, we search just to make sure that this invention has not been done before, or that is not something that is going to be obvious. And what I mentioned before is prior art, and prior art can take many shapes. It can take many forms. Oftentimes, it will be other U.S. patents or other published applications. It can be foreign patents from any other country. Just because it's in another language does not mean it can't be used against a filed invention. I mentioned journal articles, books, websites, conference proceedings, scientific papers. I should actually mention this. I had a pharmaceutical application once where I used their own Facebook disclosure advertisement about it, to let them know that, you know what, you disclosed your invention to the public. So one of the things you want to be absolutely careful about is, if you are going to file for a patent, you want to be very careful about who you tell and how you tell them and when you tell them. Because if you're out there and you're looking for funding for your invention, you want to be really careful about who you tell. So if let's say you do crowdfunding, through Facebook, hey, here's my invention. Be very careful about how much you say, because in the case of mine, they were actually disclosing to the public exactly what they were claiming in their invention. And that can really, really hurt you if you're going for that patent protection. All right, now here's the cover of a particular patent. And one thing, if you can see this, one thing you're going to recognize on here is this little spherical Muppet-shaped device. The other picture shows that it's being grabbed pretty severely in the hand on the right side of the patent cover. But one thing you're going to notice is that even if you do recognize exactly what this thing is, if you look in the top left corner, you'll see United States patent, then you'll see the name of the inventor. But next to item 54, that first bracket in the upper top left, you're going to see a really long-winded name that doesn't look like it has anything to do with what that picture is. So oftentimes when we describe inventions, we do it painstakingly. So we use as many words as possible just because we want to be absolutely clear about what it is that we're inventing. So what we have here are some examples of what some of the inventions that you'll see. So in the interest of time, I'll just kind of walk you through some of these. So occupant propelled wheeled land vehicle. So what we can take away from this is somebody has to occupy that vehicle. It's a vehicle that's on land, not on water, and it's propelled by the person who was riding in that vehicle. So while that could be read upon by many different types of vehicles, a bicycle. Small mammal trap device. I think we were giving another presentation at one point where the question of what defines a small mammal came up. In this case, we're talking about very small mammal with respect to Alaskan standards. So as opposed to maybe like an elk, we're talking more like a mouse trap. Horological instrument with musical simulated avian. The clue here is that horological or horology. If you've ever seen a Harry Potter movie, particularly the one where one of the kids goes back in time with a time turner, horology refers to time or chronology. So an horological instrument with a musically simulated avian is a cuckoo clock. And then our last one, which represents the picture, the generally spherical object with floppy filaments to promote sure capture, is a cush ball. Now, we don't have time to actually go into the interwebs and do a search for ourselves, but when you get the chance, all you truly need to do to start doing a search for patents on your own is just go to Google. Literally Google patents, and you can just type in whatever idea you can think of. and it will start turning back ideas for you. You can, it's a fun little vortex of time once you start getting into it and using it. But the more you search, the more you'll be able to search for ideas that are of particular interest to you. When you get the slides, you will have several links to some of our educational resources, one of which will take you to an example of one of our young innovators. As I mentioned before, licensing your technology, this young innovator, Marissa Strang, came up with a I'm gonna mess up the name. I want to say it's a Puff and Fluff, if I'm remembering that correctly, Julie. But
That's right.
basically, the problem she saw was that her dog absolutely hated baths, and more critically hated being dryer. It was afraid of the dryer. So what she created was a device that she could wrap her dog in, and then attach the dryer apparatus to that bag, and basically dry the dog and have the dog not get so stressed out. The idea was so successful that she was, oh sure, Puff and Fluff, there it is in the description. She was able to get she got the patent, and the patent was so popular that not only was it featured on such shows as the Jimmy Fallon Show, Tonight Show with Jimmy Fallon, but she was also able to license it to the point where she was able to basically fund her entire college career. So just an example, there's the site there that you can go. There is a YouTube video that is associated with it, so I encourage you to go when you get a minute and watch it. And those are patents. That's my end tonight. So thank you very much. And I'm going to take it back to Julie. She's going to take you through the example.
Yeah, I know you've all been waiting to make your flashlights, and you all have got a STEM kit, and so I'd like you to get out. You should have a paper. I'll hold this back. Kind of a paper template. It looks like a flashlight, although it's going to end up looking like this when we're done. So take that out, and then you should also have a battery, and you can actually go ahead and remove it from the packaging. So you can take it out of the packaging and have that ready to go. And then you also have an LED light. And an LED light is a great example of a patent that's been improved upon. Thomas Edison had one of the very first lights, the incandescent light bulb. I think Jeff may have mentioned it during the presentation, but it's been improved upon over the years, where you have this very small light that puts out a lot of bright light and uses hardly any energy. And then you have a very little sticky tab in there. So take that out, try not to lose it, put that down in front of you. And you also should have some inventor cards in your pack as well. And I'll show you where you can, I've actually given you the link over in the chat, and that's where you can go get additional inventor cards. You can download them. We have over 30 inventor cards, and they're fun to read about the inventors that we've got cards for at the USPTO. Some very familiar inventions. So what I'd like you to do first is get your LED, your light, and your flashlight template. And on the side where there's a logo, I'd like you to look at the two small holes at the top. And I'd like you to take your LED and put it through the two small holes at the top. So it should look something like this. You're going to have your light on the side that our logo is, or our trademark, right? On this side. And then on the side that you have the dotted lines, you're going to see your LED legs coming through. And if you look at it, you'll notice that one leg is shorter than the other leg. Now, what I'd like you to do is peel off just the green layer of the mounting tape that you have there on your flashlight. So I peeled off this green plaid layer, and now I just have a sticky piece of tape there. And I want you to bend the short leg and put it down the middle of that tape. So it looks something, if you can see that, like this. So you have your short leg, and that's actually the positive leg of the LED. We are actually going to complete a circuit in this exercise. So now, if you've got your LED leg pushed down, I want you to take your battery. And if you notice, one side of the battery is shiny, and there should be a little plus on that side. That's actually the positive side. But the other side that's rough, that's the side I want you to put down on the tape. So place that on the tape, and that's going to connect with the positive leg of the LED. So you're going to have the negative side of the battery connecting to the positive leg of the LED. Now, just to make sure we have it connected correctly, just touch that long leg to your battery and see if your light comes on. Watch what happens. Hey, I've completed my circuit. So once you do that, before you bend your leg down, find that little sticky tab that we had before, peel off one side of it, and stick it to your battery. And where I'd like you to put it on your battery is at the very top of your battery. So you see how I have it at the top of my battery? And then once I have it there, I can bend my leg over there so it's not always in contact with the battery. Otherwise, your battery would burn out. And then when I press it down, that's when my light will come on. Okay? So once you've got that and you bend your leg over, now we're going to fold it into a flashlight that looks like this. So you notice the dotted lines on this side. What I'd like you to do is lengthwise fold the side in along one dotted line right there. Turn it over, fold it in along the other dotted line, like so. So you see that's on the dotted line. I folded it. I'm going to fold this one in. And then that dotted line in the middle, fold it in half. Like so. Whoop. So again, let me just show you that. I folded the top long dotted line in, turned it over, folded this in on the long dotted line, and then folded it in half. And then now you're almost done. You've just got this top part, and you can just kind of like an envelope, you can just whoop, tuck it into the top of your flashlight. And then kind of bend your light so it's up like this. And then every time you press on it, your flashlight comes on. It's great to keep in your backpack, in your pocket. You've always got a little light with you, and that's your flashlight. And if you'd like other activities like this, you can go to that USPTO Kids website. We've got a lot of activities there. We've got our collector's cards, and that's a great place to go and learn more about intellectual property, because you all have ideas. And as Jeff showed you, Marissa Strang, she was a third grader when she invented the Puff and Fluff dryer for her dog. And she used a lot of that money to pay for her college. In fact, she's a freshman in college right now. So it's a great story, but you all are so creative, and I can't wait to see what you invent in the future. Any questions before we go? Did everybody have your flashlights? That looks like it. Okay, Ashley.
Yeah, thank you so much. We played along, and Pretty awesome, actually. Love it. Thank you so much. And I think that's all we had. No questions here. So thank you
Okay.
so much.
Yes, thank you for inviting us. Bye-bye.
Of course.
Pleasure.